Hello everyone, I'm Seth Weissman. Good to see you. Welcome to another episode of Safe Real Estate. Today we're going to talk about the subject of what rights does a seller have when the buyer loses their financing. And specifically, does the seller have to wait until the closing if the buyer is pursuing financing, or can the seller go ahead and sell the property to someone else? And unfortunately, the answer is it depends. In Georgia, there is a concept in the law called anticipatory breach. And if a party to a contract, through their words or actions, indicates to the other party that they are not going to perform the contract, that is known as an anticipatory breach, and the other party can terminate. So, for example, if I, as a buyer, call up the seller or I send them an email and I say, I have decided not to buy your stupid house. I changed my mind about the neighborhood. I've not been able to get financing, and I personally don't like you all that much. That would be an anticipatory breach of the contract. The buyer's clearly communicating they are not going to perform. But let me give you another situation, because this is an area where sellers have to be really careful. I'm working on a dispute right now where the buyer called the seller and simply said, my loan was turned down, I'm devastated. I wanted you to know as soon as I heard this news, and we're going to have to see what happens from here on out. The seller got another offer the very next day, and the seller decided to sell the property now to buyer number two. Well, as fate would always have it, the first buyer then calls back 4 days later and says, great news, I was able to work it out where my loan has now been approved. I look forward to seeing you at the closing next week. And the seller took a big gulp, because what the seller had now done was to sell the property to two different buyers, which obviously was a terrible mess. And frankly, if that buyer wants to continue to proceed to look for financing, as this buyer did, the seller has to wait until the closing to fully give the buyer an opportunity to purchase the house. An anticipatory breach is a subject that you have to always look closely at the facts. For example, if I, as a buyer, send you a notice that is a unilateral termination of the contract, and I send it 3 days before or 3 weeks before the closing, that is a breach of contract, and the seller can terminate due to the buyer's unilateral termination. But let's say, as a buyer, I send the seller a request for a mutual termination, and the seller turns it down. Has the buyer unilaterally breached? I would argue that this is not an anticipatory breach, because all the buyer did was ask through that mutual termination, will you consider terminating? And once the seller said no, the buyer may well have then decided to proceed with the contract. So the safest course is always to wait until the closing, unless the buyer gives clear, unequivocal information to the seller saying that they are not going to close. I hope this episode of Safe Real Estate has been useful to you. Please continue to tune in and watch other episodes. And as always, be safe, be healthy, and most of all, be informed. Great to see you all today. See you next week. Bye now.